In 2021, a judge revealed the existence of a safe in London, holding more than 30 sealed wills belonging to dead members of the British royal family, and traced the entire practice back to a scandal from 1911. The judge was Sir Andrew McFarlane, president of the Family Division of the High Court, ruling on what should happen to the will of Prince Philip, who had died that April after more than 7 decades of marriage to Queen Elizabeth. Wills in Britain are ordinarily public documents. Anyone can pay a small fee and read one once probate has been granted. That openness is written directly into the Senior Courts Act of 1981, which sets out the fee-paying process for viewing any will that has gone through the standard probate system. Royal wills had quietly followed a different rule for well over a century, and until McFarlane's ruling, most of the public had no idea the exception existed at all, let alone why. He confirmed he was the custodian of a safe containing over 30 sealed envelopes, each holding the final will of a deceased royal, and he explained, in a published judgment, exactly where that tradition had started. McFarlane went further than simply confirming the safe existed. He wrote that the degree of publicity ordinary disclosure would attract would be extensive and wholly contrary to maintaining the dignity of the sovereign. Language that made clear the secrecy was treated as a constitutional necessity rather than a mere courtesy. It began with a man named Francis, known within his family as Frank, the younger brother of Mary of Teck, who had become Queen Mary on her husband's accession to the throne earlier that same year. Frank had a reputation his own relatives did not try particularly hard to soften. A relative later told one of Queen Mary's biographers that he was terribly funny but outrageous, a man who had run up gambling debts serious enough to prompt a period of exile to India that did little to change his habits, and who carried on a long affair with Ellen Constance, Countess of Kilmorey, a married woman known to the family as Nellie. Nellie's own husband, the Earl of Kilmorey, appears to have tolerated the arrangement without public complaint, and the two men's names continued appearing together on society guest lists throughout the affair. An open secret that never quite crossed into open scandal while Frank was alive. He died suddenly in October 1910, at the age of 40, following months of declining health. He had spent that summer at a health spa in Marienbad before returning briefly to Ireland and then London, where his condition worsened sharply in the days before his death. What came next was the part that actually mattered. Frank's will, dated back to 1902, left a collection of jewelry, including a set of emeralds that had belonged to the Teck family for generations, directly to Nellie. Queen Mary was due to be crowned the following June, and the prospect of her late brother's mistress walking away with royal heirlooms, weeks before that coronation, was not something the family was prepared to let stand as public record. On the 17th of February 1911, the High Court ordered Frank's will sealed, keeping its contents hidden from public inspection. It was, as far as anyone has since been able to determine, the first time a senior, non-sovereign royal's will had ever been withheld this way. The court order itself was brief and procedural on its face, granting probate to Frank's 2 brothers without annexing a copy of the will or codicil, a formula that left no public trace of what the document actually contained. Mary did not simply let the matter rest with the sealing order. She negotiated directly with Lady Kilmorey and bought back the emeralds for £10,000, a sum worth roughly £700,000 today. She wore them within the year at the Delhi Durbar, the grand ceremony marking her and George's status as Emperor and Empress of India. Decades later, some of those same stones were reset into what became known as the Vladimir tiara, a piece Queen Elizabeth herself wore on numerous public occasions. The emerald's origin in a hushed-up scandal completely invisible to anyone simply watching her on television. Jewelry historians have since traced the stones through each of their public appearances, cataloging a piece that spent decades as a symbol of royal continuity, while carrying quietly the residue of exactly the kind of scandal the family had worked so hard to bury. Anyone admiring the tiara across those decades of official portraits and state occasions was, without knowing it, looking at the settlement of a family scandal deliberately erased from the public record more than a century earlier. The precedent Frank's death created outlived him by well over a century. Every senior royal who died afterward had their will sealed under the same convention, added quietly to the same growing collection, with no public announcement and no explanation offered. Executors simply applied to whoever held the office McFarlane himself would later occupy, and every application, without exception, was granted. By the time Prince Philip died in 2021, the safe McFarlane described held the wills of the Queen Mother and Princess Margaret, both of whom had died within months of each other in 2002, among others accumulated across the decades in between. Margaret's sealed will had already drawn one legal challenge before Philip's death, when a man named Robert Brown applied to have it opened, claiming to be her illegitimate son. The courts rejected his application, calling the belief behind it irrational, and the will stayed sealed. Brown's case demonstrated exactly what the sealing convention was designed to prevent: a private family matter turning into a public legal argument over what a royal will might or might not reveal, decades after the person in question had died. McFarlane's ruling on Philip changed one detail of the tradition without abandoning it. Where previous royal wills had been sealed indefinitely, he set a fixed term of 90 years, after which the document could be reviewed in private and a decision made about whether to publish it. No copy of Philip's will would be kept on the court file itself, and its value would be excluded from the public grant of probate entirely, two further departures from how an ordinary estate is handled. 2 years later, in February 2023, he went further, publishing a formal procedure for how already sealed royal wills could eventually be unsealed under that new rule. The procedure set out exactly who would review a will once its 90-year term expired: the monarch's own private solicitor, the keeper of the royal archives, the attorney general, and any living representatives of the family member in question, with the final decision resting on whether the document should be released or sealed again for another undetermined stretch of time. That group would weigh the same tension every time, whether enough had changed in 90 years to make the document safe for public view, or whether the family's interest in privacy still outweighed whatever historical curiosity the will might satisfy. On the 13th of June 2024, 9 of those original sealed wills, envelopes and all, were finally handed over to the Royal Archives for safekeeping and research. First on that list, 113 years after a court order first locked it away, was the will of Prince Francis of Teck. The document that emerged after over a century in that safe was, by most accounts, unremarkable to read on its own terms: a short, handwritten will naming Frank's 2 brothers as executors and settling a modest estate worth just over £23,000. Its significance had never really been about the specific sentences inside it. It was about the fact that a family had once decided some words were too dangerous to let the public see at all, and had built a system around that decision sturdy enough to outlast every monarch who has reigned since.